Hello, and welcome to this Legal Futures webinar on the SRA Accounts Rules 3 years on. Change, clarity, and integrity are the subtitles, and I will be saying a lot about all three of those things over the next hour. My name is Trevor Hellawell. I am a lawyer, a solicitor, as I'm sure you appreciate, though I've spent the bulk of my professional career on the training and consultancy circuit. And what I want to do in the next hour or so is I want just to shine a light on some recent regulatory action and just to comment on the regulators' general view as to their oversight role. I want to whiz fairly quickly through the accounts rules, paying some particular attention to the prohibition on the use of client account as a banking facility. I'll say a brief word about expenses and disbursements because I don't think we've quite bottomed out that distinction yet. And then I want to focus on the relationship with our reporting accountants, and I'll also be discussing the duties of the COFA, and in particular the notion of acting with integrity, before I just offer some miscellaneous thoughts about how we might amend our terms and conditions. Now, as far as the SRA's thinking is concerned behind the new accounts rules, and I'll call them the new accounts rules until we get a newer set, is that in the old days, the SRA found that they were receiving legions and legions of qualified accountants' reports, 4,500 back in 2015, of which, on discovery, they found only 179 showed any real threat to client money. So they altered the rules on the qualification of accountants' reports at the back end of 2016, and in 2017 they only got 900 qualified reports, of which they felt that 400 merited further investigation. So this confirmed them in the direction of travel, which of course was reinforced by the recruitment of Paul Phillip as the chief executive, whose view was that regulators only need regulate where the law is deficient or inadequate, and there'd been a lot of subsequent law that had superseded what the old accounts rules had said. So they undertook a massive revamp of the rules, as we well know, mainly in the exercise of making it cheaper and to enable lawyers more transparently to transact our business for the good of the clients ultimately. So